Hello everybody, welcome to Attorney's Corner. My name is Kamaka Faith and I am an admitted attorney of the High Court of South Africa, and I also hold an advanced diploma in estate and trust administration from the University of Free State. This channel will predominantly focus on the administration of deceased estate planning, and the administration of trust when it pertains to road accident fund trust and also medical negligence trust. In the context of Black South Africa. Now, what I have noticed in my career so far, I haven't been in the fiduciary space for that long, but in the time that I've been in the fiduciary space, I've noticed that unfortunately, Black South Africans do not really understand the concept of the administration of an estate, and more so the administration of trust. Also, the concept of estate planning. So in this channel, we will be focusing on getting our beautiful Black people up to date and just educated about all things estate planning and trust. The first thing that I hold dear to my heart and that I would love to explain to the Black community is the concept of what to do. First thing, what to do when a loved one passes away. It's a very sensitive, touchy subject. Most of us don't know where to turn to. Most of us don't know what to do in terms of when it comes to what happens when a person passes and then we have to administer the estate. Some Black people tend to want to do it on their own, and then they tend to do it wrong because they're not assisted by the relevant people, and then the families end up partying or fighting over the assets of the deceased, which is what we don't want. So what to do when a loved one passes away. I believe, for me, the first thing would be to ascertain whether the deceased had a will or did not. That is important because then it would tell us in which way the estate would be administered, whether it would be testate or intestate. But we will discuss the testate and intestate importance in a later video. Now, first you need to ascertain, did the deceased die with a will or without a will? Then for me, it would be important to gather all documentation that you possibly can of the deceased relating to his assets, the liabilities, anything that the deceased had, just to have us come up with that sum of, we need to know if the assets of the deceased are going to be over 250,000 or less than 250,000. Those two things are very important because it will then dictate us to know if we're going to be administering the estate with a letter of authority, which is a section 18.3, or a letter of executorship. But that is also something that I will discuss in a later video. Now, you gather all the relevant documents that you can find related to the deceased assets and the deceased liabilities. Now, after that, you need to report the estate. The estate, you can either, if you are a nominated executor in terms of the will, report the estate by yourself. Well, in terms of the will, you report the estate by yourself, but if there is no will, you need to be nominated as an executor, then you can report the estate and then the master can appoint you as an executor. This you can do yourself as a lay person, but I would highly recommend that you seek the assistance of either an attorney or an accountant, just to assist you with an agent. They call them agents, an agent to assist you with administering the estate, because most lay people, they don't really understand, especially in our Black communities, we don't understand the administration of deceased estates. So appoint an agent. Well, you're gonna have to, if your estate is over 250,000, you're not gonna have a choice as a layperson to administer it by yourself. The master is gonna request that you get an agent, which is either an attorney or an accountant, to assist you in administering the estate. But that's what needs to happen. You need to report the estate. The next step for me, you need to report the estate at the master's office. The master will request certain documents that you can find on the DOJ website, forms that you fill in. The master will also request additional documentation such as the deceased ID, if the deceased was married, if they were married in community of property or not, the marriage certificates, the antenuptial contracts, if there are any, and such documentation. You need to provide those to the master. And then after those are provided to the master will assess all the documentation, and if everything is right and correct and they approve everything, they will issue either, again, depending on if the estate is more than 250 or less than 250. If the estate is less than 250, the master will issue section 18.3, which is the letter of authority of a master's representative. Or should the estate be more than 250,000, the master will issue a letter of executorship. Now, once you have that letter of executorship and you are the appointed executor for the deceased estate, the first thing that you will have to do, well, the first thing that I personally do in my workspace, is I open the estate aid bank account. After I do that, I need then to advertise the fact that the deceased has passed to the creditors. It's called a notice to creditors or notice for creditors. You need to advertise that, and it needs to you need to advertise that in a local newspaper and the government gazette. This is just to inform creditors that, hey, listen, here we have a person that is deceased. If they owe you any money or they have any debt to you, you can claim. You can put in a claim to the executor with proof, obviously, stating that, listen, this person owed us this amount. Can you please pay us first before you complete the administration of the estate? And they need to do that within 30 days. That's the notice to creditors. You advertise that. The creditors need to claim within 30 days, and then not after the 30 days, during this, you can inform, you should inform them if the deceased had any bank accounts or any policies which were not specifically named to be passed on to a specific person, policies that weren't in another person's name, they would fall part of the deceased estate. Then you need to inform those policy providers, and you need to inform those banks that the deceased, in a letterhead, preferably on a letterhead of your agent that is assisting you, signed by you as the executor. You inform them that, listen, this person with their ID number, with the date of death, has passed on. They passed on this date, and they held this account number with your bank. Can you kindly check if they have any assets with relation to this account number? If there are any, please pay out to the estate bank account, and then please also close the account. So then the banks, whichever bank the deceased had money in or assets in, would then pay to the estate account. And then, but you need to inform them first. But it's not difficult to inform the banks. They do have, most banks, you can find they do have a specific email address for the reporting of a deceased, or notifying them that a person has passed on and then their assets needs to be paid into the estate account. You can just, with the agents, if you do appoint an agent to assist you, the agents would know this. They would mostly, I believe, that they would do it for you. But if you're doing it as a lay black person, as a black South African person who doesn't really understand the states, these are the steps to follow. Now, you inform the banks, you inform any policy holders, any policy providers where the deceased did not specifically state that their policy funds need to be paid to a specific person. Those form part of the estate. You need to inform those so they can pay out to the estate. Now, please, my people, your pension fund, it does not form part of the deceased estate. That is governed completely by separate legislation. It does not form part of the estate administration process. So leave that out. Do not go to his to their workplace and saying, hey, the pension, we need the pension money for this. The pension, it's governed completely by its own laws. So now you get all of this stuff. You got the will, you got all of the documentation, you got your letter of executorship or your letter of authority. You opened your bank accounts. You then advertise your notice to your creditors. If the estate is over 250,000, the next thing you need to do after the 30-day period has passed for the notice for creditors to put in their claims is now you need to draft and something that is called a liquidation and distribution account, which you then need to submit to the master's approval. And once the master approves that, it needs to lay open for inspection for 21 days, so that just if anybody has any objections to it, they can submit those objections to the liquidation and distribution account. Now, you also need to advertise that there is a liquidation and distribution account that is laying open for inspection at the master's office. Now, you put in a different. This is a different one from the previous advertisement. Now, you need to advertise this, that there is a liquidation and distribution account that is laying open for inspection at the master's office, and lays there for 21 days. And you also advertise this in a local newspaper and in the government gazette. And then once it's laid open for inspection for 21 days, there are no objections. Then the next step into the administration process is then you can now you can pay out to the heirs or the beneficiaries. You can distribute, pay out to the heirs what you can in terms of the estate. And then after you do that, you can ask the master then for a finalization, for confirmation that the estate can be deemed as finalized. You're going to submit a few documents for the master to deem it to the master, just to show that they can deem it finalized. The master would request from you to submit the proof of advertisements, your proof of payment to the beneficiaries and the heirs. You need to provide them with bank statements and clearance certificates and any other relevant documentation that the master might ask for. And then they will give you confirmation that the estate then can be deemed, it can be deemed. They can confirm that the estate can be deemed as finalized. That is the process. That it sounds complicated and it also sounds stretchy, because it is a lengthy process depending on how long the master takes to issue that letter of authority, and it also depends on how long it depends on how long the banks also take to pay out the funds. Another thing that can take long is the transfers of the property. If there's any fixed property, that also needs to be transferred. But the fixed property, in terms of estates in Black communities, is something that I will deal with specifically in a video dedicated on its own, because I believe that is a concerning issue in Black communities when it comes to just transferring the assets to the people who have the right to inherit from the deceased estate. So yeah, that is the process, or basically what needs to happen when a deceased passes away, or when a loved one passes away. That is what needs to happen. What needs to happen for the estate to be fully administered. This thing of us as Black South Africans, the reason why I started this whole channel is because I've been seeing platforms I will not name the name of the channels, but there are platforms in which they inform or they tell us as black, in the black community, that hey, listen, if someone passes away, get the letter of authority, get the letter of executorship, and then what? And then do nothing with it. We don't administer the estate. We don't go through the right channels, the proper channels, to make sure that the assets are distributed to the heirs. We just sit there with the letter of authority and we don't do anything with it, which is, for me, is a problem, because now it creates it, it creates, how do I even, it implies, it gives people a false, it's false information to people, that you can just get the letter of executorship or the letter of authority, you just sit with it, and then what? Some people even believe that once they have that letter of executorship, once they have the letter of authority, they believe that the deceased assets now belong to them. They're the holders of the assets, and that is completely false. That is not how it works. You need to administer the estate. You need to make sure that you distribute the estate to the relevant heirs of the estate. The assets are not yours to keep as the nominated executor. You, as a nominated executor, are there to administer the estate in a proper and legal way, to make sure that everything is done correctly. But I've been seeing on these platforms, I've been seeing on these channels, that they say, hey, do this, get your letter, and then you can evict people, and then you can do this, because this is now yours. The deceased assets are not yours just because you hold a letter of executorship or a letter of authority. That little paper tells you that you have the authority to administer this estate, to make sure that the assets of the estate, they go to the relevant heirs or the relevant beneficiary. They're not for you to keep because you are the nominated executor. That is not what it means, and this is why it is so important for me to just share the information of what needs to happen when a loved one passes, and just give, also not just share information, but just the knowledge that I have, and just pass it to my fellow black South Africans, so that they have an inkling, an idea of how things work, how estates are administered, how trusts are administered, and also how to plan for your estate planning, and how to plan for the future for such things, so that not only, because we don't really have this knowledge in townships, in rural communities, we don't know. Some of us don't even report estates. Some of us just in especially in rural communities, we just when a person passes, we just take on the assets as our own. It bothers me to the core, because the wrong people end up taking the assets and leaving those who have a right to inherit destitute with nothing, especially when it comes to the children. It is so important that you need to administer estates correctly, so that the relevant people who can inherit from estates do inherit from those estates. So it's a problem for me to be seeing brothers and sisters of a deceased fighting for deceased property and saying, no, we have the letter of authority, we have the letter of executorship, this is our stuff. It is not your stuff. It is for you to administer, to make sure that if there is a spouse, what if you're the nominated executor and you are a sibling, administer the estate. The assets do not belong to you. The assets belong to the people that are nominated in terms of the will, or the interstate heirs. If there is no will, it does not belong to the person who is nominated or appointed as the executor. That is false information that I've been seeing, that is spread on specific TV channels, which I will not name, but it is troubling to me. It troubles my heart to see that. So that is why I thought, you know what, I'm just gonna start a channel, and in this channel I'm just gonna give information. I'm gonna share the knowledge that I have, and I'm gonna try and make the black community better and just inform them. Should this happen, this is what you need to do, this is the process that you need to follow. And yeah, that's it. I hope you enjoyed the video. Please like, share and subscribe, and I will be uploading other videos just with more information of what I call the circle, this type, within this type of circle in the fiduciary industry. Thank you for watching. Have a beautiful day further.